Hello and welcome to In Focus. I'm Aratrika Bhomik. Last week, reports emerged that Indian authorities had allegedly transported dozens of Rohingya refugees to the Andaman and Nicobar Islands and abandoned them in international waters in an attempt to deport them to Myanmar. However, a Supreme Court bench comprising Justices Surya, Kant and N. Kotiswar Singh declined to issue any interim order halting this alleged deportation. The court has also questioned the credibility of the evidence presented before it. Meanwhile, the United Nations has launched an inquiry into the incident and has urged the Indian government to refrain from inhuman and life threatening treatment of Rohingya refugees, including their repatriation into perilous conditions in Myanmar. To discuss whether the Indian government's deportation policy towards the Rohingya refugees violates established principles of international law as well as constitutional principles, we have with us today senior advocate Colin Gonsalves, renowned human rights advocate and the founder director of the Human Rights Law Network. Thank you so much for joining us today, sir.
Thank you.
Dr. Gonsalves, before we turn to the UN investigation and the recent developments, if you could start off this conversation examining India's approach towards refugees so far. So, from my understanding, there isn't a consistent policy that India has followed. For instance, it has provided asylum to those affected by the 1971 War of Independence in Bangladesh, as well as it has granted asylum to Dalai Lama and the Tibetan refugees who followed him into exile. Why do you think we see a differential treatment when it comes to Rohingya refugees? And do you think it is time that India comes up with a comprehensive domestic refugee law?
Well, let me start by saying there is a consistent policy. And that consistent policy has run from independence till the time Mr. Modi's government took power. And the consistent policy is to follow international law, to follow the principles and practices of the Refugee Convention. Although India has not signed it, India agreed to abide by that broadly. And India agreed to abide by the judgment of the Supreme Court in the NHRC case, which was delivered in the context of Chakras. So we had unbroken, proud policy that we will protect refugees. Let me clarify that this doesn't mean that we will allow all migrants to come to India and stay in India as long as they want. But since a refugee is different from a migrant, in the sense that the refugee does not come voluntarily to a country, the refugee essentially flees persecution. And in the case of Rohingyas, they were running away from Myanmar after the Rohingyas were killed, their wives were raped, their houses were burnt. Terrible, terrible injustice was done to them. And they had no choice but to leave. So it's not an act of volition where you leave one country and come to another. And a refugee certainly can't stop at the border and make an application for a visa to come to India. You run to save your lives and you come to India. We had a long and proud tradition, which now lies in tatters because the present government doesn't believe in the rule of law. And right from the Tibetans who came here, when the Tibetans came here, Nehru personally met the Dalai Lama halfway after he had entered India and welcomed him to the sanctuary of India. When the Sri Lankan Tamils ran away and came to India, even though India had played a terrible role, almost a genocidal role of attacking the, the, the Sri Lankan Tamils in the north, but we gave them refuge when they came here. We didn't catch them and send them back immediately. When the Chakmas came, we agreed to house them. We said we'll give them citizenship. So India had a very proud tradition, even without signing the Refugee Convention, of abiding by the rule of law in respect of refugees. And what that means is that the Indian government will not return the refugee who has fled persecution, will not push them back to the country into the hands of those, the Myanmar army basically, who want to kill them and rape them and torture them all over again. We will not be instrumental or the cause of a second round of torture and rape and killing.
Right. So you're referring to the non-refoulement policy. Now, for a bit of context for our viewers here, as Dr. Gonsalves mentioned, even though India is not a signatory to the 1951 Refugee Convention or the 1967 Protocol, it is still bound by the customary international law principle of non-refoulement, is it?
You've said it perfectly. Customary international law, when it is applied again and again and again across the world, and once it is recognized throughout the world, then it attains the status of just cogens. Just cogens is a principle in jurisprudence, which means it's a principle of international law where no state can resile from that policy. India can't say we're not a signatory, we don't agree.
Right. And apart from the Refugee Convention, India has, however, ratified other international treaties such as the International Covenant on Civil and Political Rights, which is the ICCPR, the International Convention on the Elimination of All Forms of Racial Discrimination. So, do you see this principle of non refoulement as well as the obligation on Indian authorities not to deport refugees without due process? Do you see these obligations kind of emanate from these ratified treaties as well?
It comes from a lot of conventions and treaties, and it dates back to the Universal Declaration of Human Rights, where India was so proud to have Vijayalakshmi Pandit, the sister of Jawaharlal Nehru, take a lead on that. So India, from being once upon a time a world leader in terms of human rights and international rights, today we are a pariah nation because we have renounced everything that made us so great. And we don't even need to look at any UN convention. We can look closer to home, the decision of the Supreme Court in the NHRC case, National Human Rights Commission versus State of Arunachal Pradesh. And this was the judgment delivered in the Chakma matter. And in the Chakma matter, the Supreme Court said we are a nation governed by the rule of law. Article 21, which is the right to life, governs everyone within the territory of India.
Hmm.
What that means is, the Supreme Court clarified, it covers not just citizens but non citizens alike. So, refugees running away to save their lives and women running away to prevent, rape and so on, they come here. It is the duty of the Indian government to protect their lives. And in that context, the Supreme Court said, Article 21 then binds India
Right.
not to send them back. So the principle of no refoulement, you may look for it in various UN conventions and treaties, but you just have to open our law journal of that period and see what the Supreme Court said. It incorporated the principle of non refoulement in Indian constitutional law. So, are they constitutionally protected? The answer is an emphatic yes.
Right. And just to reiterate, that means, like you consistently mentioned, that the Indian government's characterizing them as a national security threat. They do not align with constitutional principles of Article 14 and 21, which are also available to non citizens.
Well said. But I'd add a little bit more. Even on the factual issue, I heard politicians saying that, look, these guys are criminals. They are a danger to the nation, therefore we should send them out. So when it arose in the context of Jammu, where there were many refugee camps, and it was said by Rijuju then, the Home Minister, he said we are going to deport all of them en masse because they're all terrorists. So what I did is I traveled to Jammu. I think at that stage there were about 20 police stations where the Rohingyas were living. I went and met the SHOs, the station house officers at each police station, and I asked a simple question. Are there any of the Rohingyas who live in this area, are any of them charge sheeted under UAPA for being a terrorist? And they said no. And next they said no. And next they said no. And I covered all the police stations. And I found that there was not a single Rohingya out of hundreds who had a UAPA charge against them. A week later, I just finished, a week later, the Director General Police of the state of Jammu and Kashmir made a declaration because there was news in the papers that terrorists are being harbored. The Rohingyas were terrorists. He said, we have no record of any Rohingya terrorist in the state.
You of course mentioned that there has been consistent jurisprudence of the Supreme Court. You mentioned NHRC versus Arunachal Pradesh. In fact, if I may add, you've also had the Gujarat High Court in Abbas Habib versus Union of India, and the Delhi High Court in Lian Khan versus Union of India, where they have established that the right to non-refoulement, as well as protecting refugees, giving them asylum, protecting them against arbitrary detention, they fall under Article 21. However, in the recent years, we have seen Supreme Court take a different stance altogether. Like we discussed previously at the onset of the discussion, that the Supreme Court in the last hearing has refused to pass an interim order. So, do you think there is clarity required from the Supreme Court in establishing a more consistent jurisprudence, because we don't see prior precedents being followed here?
I don't think we need clarity. It is something deeper than clarity. I think I'm not referring to any particular case. I think the government and the judiciary know exactly what's going on. But the most important aspect of the judiciary is the independence of the judiciary from political interference, which means that you stand up to the government. And if judges of the high courts and the Supreme Court don't have the courage to stand up to government, what is left of your judiciary? What happens to the constitution? What happens to the social conscience of the constitution which Baba Sahib Ambedkar spoke of? The social conscience. Has it all disappeared? So the constitution has become irrelevant. And Justice Gavai said it recently. It's the supremacy of the constitution, not the supremacy of the government. It's the supremacy of the constitution.
Right. And now that you have these precedents from the Supreme Court, do you see the High Courts following suit as well in developing this kind of jurisprudence where they do not extend asylum or protection to refugees?
Well, if the Supreme Court says something, it's akin to the word of God. It isn't, of course, far from it. And suppose these 50 Rohingyas were put in the sea and landed up in Myanmar. Suppose we get reports that they have been killed because they were in a war zone. They were in a war zone with bombs and gunfire all around. The government of India surely will have blood on its hands. Is it not? Who in the government will be responsible?
Dr. Gonsalves, you've of course represented these Rohingya refugees before the Supreme Court in the recent hearing, like we discussed before. And according to reports, most of these Rohingya refugees also possessed UNHRC issued refugee identification cards. So, what I essentially want to understand is, does the possession of these identity cards confer a sort of legal status which differentiates them from undocumented migrants?
Yes, of course it does. Let me explain. You see, India has not signed the Refugee Convention, so it's caught in an in between space. It recognizes the principles of protection, but it's not officially signed. So, every country, the government itself does the refugee determination. But India has not signed. So, India wanted to keep that little camouflage intact. So, they said, listen, we don't do it because we've not signed. So, we'll get the UNHCR to do it. And the UNHCR has been doing it for the last 30 years. Every 6 months or so, maybe even more frequently, the mail goes from UNHCR Delhi to the Home Minister telling him, sir, these are the refugees we've given cards to. And they give them full details of the interrogation process. They tell them these are from these areas, this is the name, this is the person, and they check one thing. You are, I think, still even today, not allowed to give a UN refugee card to a person who's a proven criminal. So obviously they're not criminals. And they've come to India, they've got a refugee card, and the Home Minister knows exactly how many there are. It's not secret. And where they are, where they stay. If they shift from one place, suppose they go from Jammu to Bangalore, information goes that he's no longer in Jammu, he's in Bangalore. So it is an official thing. Government is loath to accept it, but in fact and in every sense of the term, that is a correct and lawful registration process, and these cards mean the world to a refugee. It saves them from being killed. It saves them from being deported.
Right. And from the latest figures, currently there are at least 20,000 Rohingya refugees registered with the UNHRC. And like you mentioned, all this data is available to the Ministry of Home Affairs. So they are cognizant of these refugees, and that gives them a distinct legal standing apart from illegal migrants. Dr. Gonsalves, now that the United Nations has launched an investigation into this incident that has been reported, and that the Supreme Court, you also filed a petition before the Supreme Court. Do you see this prompting the Indian government to somehow reconsider its current policy towards the Rohingyas? Do you see a change happening?
See, I hope it happens, but I have no hope in this government. And I fear, I'm terribly afraid of this government actually deporting more. To hell with international opinion, to hell with international law, to hell with customary international law, to hell with what the UN says.
But in case the United Nations investigation finds that these Rohingya refugees were thrown into international waters and this arbitrary deportation process did take place, is there scope for the UNHRC to, let's say, take punitive measures against the Indian government or advocate for the rights of these Rohingya refugees?
See, you know the world, and you know how important India is to to the developed world. So India is a very good business partner. So the developed world is also losing its conscience very rapidly. So earlier they would take India to task, but I think now the developed world doesn't have the capacity to take India to task at all. Every world leader has lost his or her conscience. I see no hope for UNHCR taking any action against the government. I had hope that the judiciary would. The judiciary is still full of very fine judges. At least half, if not more, of the judiciary is full of very good judges, but all scared now that if they act, maybe they'll be superseded and not taken to the Supreme Court.
Right. And of course, we see all this in the context that Myanmar is already facing trial at the International Court of Justice for alleged genocide. We have had statements from the UN repeatedly describing the violence against the Rohingya community as a textbook example of ethnic cleansing. Since we have established that you do not see the present government, changing its stance towards these refugees, do you think what the Indian government instead can do is play a constructive role in, let's say, facilitating their resettlement in ally countries and probably advocating for resettlement in international forums like the G20 summit? Do you see the possibility of that happening?
A very slim possibility for the simple reason that developed countries across the world have cut down their budgets on human rights and refugee protection. So the number of people who can be sent abroad to live abroad will be less and less every year.
That brings us to the end of the discussion. Thank you so much for such an insightful conversation.